is an act to implement recommendations of Right to Know Advisory Committee concerning a public records exception for proposed legislation, reports, and working papers of the governor. But it's important to note that this was not a unanimous recommendation. As head of the ACLU of Maine, I'm a member of the Right to Know Advisory Committee and have been for the last 7 years. I'm also a member of the Maine Freedom of Information Coalition. What this bill would do is allow any reports, working papers, drafts, inter-office and inter-office memoranda used or maintained by the governor or any employee of the governor's office to be held secret until proposed legislation or reports are finalized and presented to the legislature or until the termination of the legislative session. This is very concerning. This language is so broad and so vague that the governor could keep virtually anything secret if he proposed that he were intending legislation or a report to come from that information. It would give the governor too much discretion in declaring official public records off limits. We believe the public's right to know is fundamental to a healthy democracy and sound decision-making by our elected leaders. The governor is a paid public servant, and his business is the public's business. While current law allows legislators to shield working papers from scrutiny, the unitary nature of the executive branch gives the governor far more power and access to information that makes this exception far different. And in fact, the legislative exception, legislators have deadlines by which they have to turn in bills. And so the timeline by which information may be kept secret is much more limited. The public has an undeniable right to know who is developing, writing, and influencing public policy. Secrecy breeds public distrust in government and potential corruption. The danger of corruption and secrecy far outweigh any inconvenience caused by our long-standing right to know laws. And finally, we think it's important to know that this isn't about Governor LePage. This is about all future administrations. We should not write permanent changes in our laws that shield information potentially for decades into the future. With that, I'm going to turn it over to George Smith.